Welcome back to the channel where I cover missing persons, unsolved cases, crime news, and more. Sadly, the the conviction of Adam Montgomery, the sperm donor for Harmony, was overturned by the New Hampshire Supreme Court. Now, I am going to go through their decision momentarily here. While this really sucks. Let's just put it out on the table. It really sucks. The bottom line is the Supreme Court justices, they decided that Adams' murder charge should have been tried separately from the child assault charge that was brought on from months earlier, uh, because the jury hearing both kind of would have given them unfair information and could have swayed them to make one decision or another. So they are they're basically saying it needs to go back to trial. Uh, but again, that's not necessarily a bad thing. That doesn't mean he's not going to be again charged with the second degree murder of Harmony Montgomery, because I feel like they can now add anything else. There's things that could be put on the table. And I don't believe that they are in any hurry to put, a trial back on for Adam. He's not going anywhere. I mean, he's got like 44 years without the murder charges in prison. So again, Adam's not going anywhere uh anytime soon. So but we are still here, okay, for justice for little Harmony. And when this trial does happen again, and it will, we just don't know when, you guys know I will be covering it here uh, again to keep this justice going for sweet little Harmony. And this is the Supreme Court of New Hampshire's findings. It was released on June 11th, as you can see here. So I'm going to kind of go through it for you guys in case you're interested, besides just the the basics that he's going to go back to trial for the murder of sweet little Harmony. And it's a horrific case, as we all know. And there's certain witnesses that I don't feel for having to go back through it. The one I feel the most for is her brother, Jameson. Uh, Obviously, he didn't testify or anything of that sort, but having the knowledge that this is going to go back through is going to be a big deal for him and his family when it does happen. So this says Hillsborough Northern Judicial District. And of course, up here it does say the Supreme Court of New Hampshire. The state of New Hampshire versus Adam Montgomery. This was argued on October 15th of 2025, and the opinion was issued on June 11th of 2026. And of note, this is how long these Supreme Courts take. I know there's a lot of folks that have been waiting, and I'm been waiting for the decision on another case, which I'm not going to get into, but Alexi Trevisio's case. So again, you have October 15th to June 11th of this year. So you see how many months it's taken for New Hampshire to make this decision as far as this case is concerned. John M. Formella, Attorney General, and Anthony J. Galderi, Solicitor General, Sam N. Goya, Assistant Attorney General on the brief, and orally for the state. Pamela E. Flan, Senior Assistant Appellate Defender of Concord on the brief and orally for the defendant. 1. The defendant, Adam Montgomery, appeals his convictions following a jury trial in Superior Court of second degree murder, second degree assault, falsifying physical evidence, witness tampering, and abuse of a corpse. We affirm in part, reverse in part, and remand. Of course, it's referencing all those statutes there. Then they go into the statement of facts. 2. The jury could have found the following facts. The defendant was the biological father of the victim, Harmony Montgomery. In February 2019, the victim went to live with the defendant and his wife, Kayla Montgomery, at the defendant's grandmother's home in Manchester. In July 2019, When the first charged offense occurred, the victim was 5 years old. The other occupants of the home at that time included the defendant's uncle and the two biological children of the defendant and Kayla. Both of those children were younger than the victim. 3. The defendant's uncle returned home in July from a 3-week trip and saw the victim in the kitchen with a black eye. The uncle asked the victim what she had done, and the defendant answered, quote, "She didn't do anything. I bashed her around the effing house." Unquote. The uncle testified that the defendant said, quote, he put the victim in charge to watch, unquote, her 5-month-old brother, while the defendant used the bathroom, and when the defendant returned, he found the victim with her hands over the baby's mouth and, quote, had his lips were supposedly blue, unquote. You don't leave a 5-year-old in charge of a baby. Yeah. 4. On November 27, 2019, the defendant's family was evicted from the home in Manchester. The defendant, Kayla, and the 3 children began living in their car, which they parked at a friend's apartment complex in Manchester. Although the victim was toilet trained before she was 3 years old, she started to have accidents once the family began living in the car. When the victim had an accident, the defendant became angry and would hit her in the face or on the leg or hand. The defendant became angrier the more accidents the victim had and would hit her repeatedly. Poor little Harmony. She's she's traumatized by this, and I won't call him her biological father. I call him the sperm donor, okay? Teardrop, aka Adam. We call him Teardrop around here. He he's a monster. That's the bottom line. He's a monster, and he could care less about Harmony. He really could care less. 5. On December 7th, 2019, the victim had an accident early in the morning, and the defendant repeatedly punched her in the head. Later that morning, the family drove to a methadone clinic where Kayla and the defendant took turns going inside while the other stayed in the car with the children. When the defendant returned to the car, he realized the victim had another accident and started yelling at her and hitting her in the head repeatedly. How I wish we could all beat him in the head. But fortunately, there were some fellow inmates before Adam was transferred, Teardrop was transferred, that gave him a bit of his own medicine. Yeah. 6. From the methadone clinic, the defendant drove the family to Burger King. While they were driving, the victim was in the back seat crying and making a strange moaning like noise. The defendant told the victim to shut up, and at each red light at which they stopped, the defendant reached back and repeatedly punched the victim in the head. The defendant stopped hitting the victim when they got to Burger King. With the final punch, he said in a scared voice that he felt something and thought he really hurt her this time. I don't think it was a scared voice. I think he was just like, I think I really hurt her this time. 7. Later that day, the family's car broke down at a traffic light and they had to abandon it. As the defendant and Kayla were getting the children out of the car, the victim did not respond and they realized she had died. The defendant got a duffel bag from the trunk, put the victim's body in it, and brought it back to the friend's apartment complex where the defendant put it in a snowbank. 8. Following the loss of their car, the family stayed in a friend's car, then with Kayla's mother, and then from December 30th through February 20th at the Families in Transition (FIT) shelter in Manchester. The defendant brought the duffel bag containing the victim's body to each place they stayed. At FIT, the defendant put the duffel bag in the ceiling vent in their room. When the victim's body began to smell and leak fluid, the defendant put the body into garbage bags, which he then stuffed into a diaper bag. The defendant worked at a restaurant at that time and would store the bag in the restaurant's freezer while he was there. Yeah, you guys remember that when I read the probable cause affidavit? It's bad. I mean, this is telling you some stuff, but it's bad. I will link to it if you would like to hear it, but beware. It's you don't want to have eaten while you listen to it. 9. The family moved from Fit to an apartment in Manchester. There, the defendant kept the victim's body in the apartment's freezer. The defendant began discussing getting rid of the victim's body and devised a plan to dismember her and use lime, which he believed would hasten the decomposition of the body. 10. On February 26, the defendant withdrew cash from an ATM and purchased lime, an angle grinder, a blade, and a battery. At some point thereafter, the defendant thawed the victim's body in the bathtub at the apartment and had Kayla remove the victim's clothing. The defendant had a large bag of lime and spent several hours in the bathroom with the victim's body. When the defendant was finished, he put the victim's body back into the diaper bag and put the bag back into the freezer. 11. On March 3rd, the defendant and Kayla stayed at a Econo Lodge with a friend of the defendant and the friend's girlfriend. The defendant had asked the friend to rent a U-Haul for him because, quote, he needed to move stuff, unquote. That evening, the friend arranged the rental. Back at the hotel, the friend and the defendant went outside to smoke a cigarette, and the defendant began pacing back and forth, repeating, quote, I effed up. 12. The defendant left the hotel in the U-Haul in the middle of the night. He took the diaper bag containing the victim's body with him and returned without it, telling Kayla he, quote, got rid of her, unquote. 13. After the defendant killed the victim, he began telling people that he had returned the victim to her mother in Massachusetts after Thanksgiving in 2019. The victim's mother, however, had not seen the victim since April 2019. Thereafter, the victim's mother tried to contact the defendant and Kayla but was unsuccessful. By December 2021, the victim's mother had reached out to state and local agencies and officials to try to find her daughter. At that point, law enforcement became involved in the search for the victim. And I feel like they're leaving out a very important part here on 13. Crystal, who they're referring to, the one who gave birth to Harmony, it wasn't Crystal who gave a crap about her daughter. Okay, not at all. It was Jameson, her brother, who asked his fathers about his sister because they were very close. And they are the ones, Jameson's fathers, that reached out to Crystal to try to arrange for Harmony and Jameson to see each other. And that is when Crystal decided to get off of her ass and do something. But up until that point, she could care less. 14. The defendant was indicted on one count of each of the following offenses: second-degree murder, second-degree assault for having struck the victim in July of 2019, falsifying physical evidence, and witness tampering. He was also charged by criminal complaint with abuse of a corpse. The defendant filed an assented to motion to join the charges for trial, which the court granted. Subsequently, however, the defendant moved to sever the second-degree assault charge from the other charges after receiving a Zwicker letter from the state imparting information from Kayla Montgomery that marks a substantial departure from her prior statements. The trial court denied the motion. And I have a video when this was happening, so I will link to that as well. I'm going to put the playlist, my Harmony Montgomery playlist. So if you are newer to this case, please do check that out. 15. The defendant also filed a number of motions in limine, which, as relevant to this appeal, included the motions to exclude 1. Evidence that he prevented the victim's mother from seeing the victim. 2. Evidence of his abuse and neglect of the victim other than the charged conduct. And 3. Evidence of his encounter with the police on December 31st, 2021. The trial court denied the defendant's motion with respect to interference with the victim's mother's attempts to see the victim. With respect to the remaining 2 categories of challenged evidence, each motion was granted in part and denied in part. While the court limited what the defense could introduce, it declined to include all of the evidence in each challenged category. 16. The defendant was tried before a jury in February 2024. In his opening statement, the defendant's counsel told the jury that it can and should find the defendant guilty of falsifying physical evidence and the abuse of a corpse. He asserted, however, that the defendant committed those crimes to protect Kayla, who was the last person to see the victim alive and know how she died. He contended that the victim did not die during the day on December 7th, but during the previous night while the defendant was running around trying to make money to get them out of their situation. And Kayla was alone in the car with the children. He told the jury that it would not hear truthful testimony from Kayla and that the only reason she has to lie and point the finger at the defendant is because the truth points the finger at her. The jury returned guilty verdicts on all charges, and this appeal followed. Yeah. So the state made a deal with Kayla, which really does suck. I mean, we've discussed that before. But a lot of times the district attorney's office does do that. They make deals with certain parties that may have been involved in a horrible crime to get the bigger criminal, and they wanted Adam. Now, it doesn't mean Kayla didn't spend time in prison, because she did. But as I record this, she is out there. She was released, and she's regularly having to check in. I believe she has to do regular urine testing, that sort of stuff. But she is not allowed near her children. 2. Analysis. A. Severance. 17. The defendant first argues that the trial court erred in denying his request to sever the second-degree assault charge from the other charges. The trial court's decision to join or sever charges is discretionary. We will affirm its ruling unless the decision constitutes an unsustainable exercise of discretion. State versus Gerard. To succeed on appeal, the defendant must demonstrate that the ruling was clearly untenable or unreasonable to the prejudice of his case. 18. The New Hampshire Rule of Criminal Procedure 20 governs the joinder of criminal offenses and distinguishes between related and unrelated charges. It provides that if a defendant is charged with 2 or more related offenses, either party may move for joinder of such charges. The trial judge shall join the charges for trial unless the trial judge determines that the joinder is not in the best interest of justice. By contrast, unrelated charges may be joined only upon written motion of the defendant or with the defendant's written consent, and upon a showing that failure to try the charges together would constitute harassment or unduly consume the time or resources of the parties. State versus Brown. And they're also referencing a lot of New Hampshire criminal procedure information there for anyone interested, because that's what they do on all these motions. 19. The defendant argues that the trial court erred in finding that the charges were related for purposes of Rule 20. Alternatively, he argues that even if the charges were related, the court should have severed them in the interests of justice. We need not address the defendant's first argument because we conclude that the best interest of justice required severance of the charges. As a threshold matter, we note that neither party argues that the best interests of justice prong of the joinder analysis must be based on the evidence before the trial court at the time of its pretrial ruling. Accordingly, we do not confirm our best interest inquiry to the pretrial record. And they're referencing, it looks like C.F. Brown. Considering the defendant's arguments were based in part on trial events, where the state did not contest whether trial events may be relevant to our review of the trial court's pretrial decision on joinder. 20. Under the best interest of justice standard, charges should be tried separately whenever it's deemed appropriate to promote a fair determination of the defendant's guilt or innocence. In essence, when conducting a single trial would jeopardize the defendant's right to a fair trial. And that references State versus Rivera in 2022. In making a best interest of justice determination, trial courts must evaluate whether, in view of the number of offenses charged and the complexity of the evidence to be offered, the trier of fact will be able to distinguish the evidence and apply the law intelligently to each offense. The best interest of justice determination may also entail consideration of other factors, including whether some charges are likely to unusually inflame the jury against the defendant. The evidence in support of some offenses is weak, while the proof of others is strong. The defendant's available defenses for different crimes are inconsistent, or the defendant wishes to testify as to one offense but not as to the others. 21. The defendant argues that joining the charges gave rise to a risk that the jury would use evidence of the July assault for an improper propensity purpose when considering the second-degree murder charge. He notes that Kayla's testimony provided the only direct evidence that he fatally struck the victim and asserts that Kayla had significant credibility defects. Specifically, he contends that the evidence undermining Kayla's credibility included her felony perjury convictions for lying to the grand jury, her prior criminal history, her other criminal conduct that the state argued not to prosecute her for in exchange for her testimony, as well as numerous self-serving and inconsistent statements about what happened in December 2019 and thereafter. Well, yeah, she did make a proffer with the state. I mean, that's never been denied. And yeah, she was out to save her ass, but do I think that she had any part beside what she admitted to? I don't think so, but is it possible? Sure. But I do think what she said, Adam beat her to death. I think that's exactly what happened. 22. By contrast, the defendant argues the state's case on the July 2019 charge was strong and rested on testimony from several witnesses without such credibility issues. The defendant contends because the charges involved in the allegations the defendant struck the victim with his fist at different times, places, and contexts, there was a substantial risk that a jury hearing the strength of the state's case on the July 2019 charge would draw the improper inference that he similarly struck her in December and thus dismiss any doubts it might have as to his guilt on the homicide charge. And I get it. I do get it why they've done this, why they've decided to overturn this murder conviction. But it's horrible because certain people are going to have to go back through all this. And yes, the state of New Hampshire is going to have to pay for another trial that Adam probably won't show up to. 23. We agree that the state's case on the second-degree assault charge was strong. 3 witnesses testified to observing the victim with a black eye in July 2019. 4 witnesses, including 2 who observed the victim's black eye, testified that the defendant admitted striking the victim. Although 2 of the admissions were made near the time of the assault and 2 were made years later, each witness testified to a consistent explanation given by the defendant that he hit the victim because he saw her with her hand over the baby's mouth, suffocating him. 24. As to the homicide charge, only Kayla's testimony directly implicated the defendant in the victim's death. The state disputes, however, that the evidence on that charge was weak, arguing that so much of what Kayla said was corroborated by physical evidence that it was easy to credit the parts of her testimony that lacked such corroboration. Specifically, the state contends 1. Kayla's testimony that the defendant stored the victim's body in the ceiling of the room it fit was corroborated by DNA and fingerprint evidence taken from the ceiling. 2. Kayla's testimony that the defendant stored the bag containing the victim's body in the freezer at work was corroborated by 2 of the defendant's co-workers who testified they saw the defendant entering or leaving the restaurant's walk-in cooler with a bag. 3. Kayla's testimony that the defendant planned to dismember the victim's body and accelerated its decay with lime was corroborated by evidence that a $500 cash withdrawal was made from Kayla's joint bank account 22 minutes before a nearly $400 cash purchase of items, including a bag of lime and an angle grinder, was made at a nearby Home Depot. And 4. Kayla's testimony that at the night she, the defendant's friend, and the friend's girlfriend stayed at an Econo Lodge, the defendant used a U-Haul to dispose of the victim's body was corroborated by testimony of the friend, his girlfriend, and the person who rented the U-Haul. This evidence, however, supports only Kayla's testimony about the defendant's actions after the victim's death. It does not corroborate Kayla's testimony that the defendant killed the victim on December 7th by repeatedly punching her in the head. It's also not inconsistent with the defendant's theory of defense, namely that Kayla caused the victim's death and the defendant helped her cover up her crime. 25. As additional evidence supporting Kayla's testimony that the defendant, rather than she, killed the victim, the state cites the defendant's friend's testimony that the defendant paced outside the Econo Lodge repeating, "I effed up." And another friend's testimony that in 2021, the defendant told her that he hated the victim right to his core because she reminded him of her mother. Yeah, he hated Harmony because she reminded Adam of Crystal. This evidence does support the proposition that the defendant displayed a consciousness of guilt for something he had done, that more than a year after the victim's death, the defendant had profound animus toward the victim. It does not, however, corroborate Kayla's account of the victim's death, as compared to the evidence of multiple disinterested witnesses substantiating the July assault. The offense, the evidence of the December 7th, 2019 fatal attack is substantially weaker. We therefore conclude that this disparity created a significant risk that the jury would rely on the strength of evidence that the defendant struck the victim in anger in July to conclude that, as Kayla testified, he similarly and fatally struck the victim in December. And they're referencing Brown again, noting that the state may gain an unfair advantage if a weak case is joined with a strong case. The joint trial of offenses creates a significant risk that the jury will convict a defendant upon the weight of the accusations or upon the accumulated effect of the evidence. 26. The state contends that there was no such risk because evidence of the July assault was presented separately. The offenses were discussed separately in the state's closing, and the jury was instructed to consider each indictment separately and not let a verdict of guilty or not guilty on one of the indictments influence its verdict on another indictments. The state argues that these cautionary statements are significant since juries are presumed to follow the instructions of the trial court. State versus Manna, 1988. This argument is predicated on a more sanguine view of the efficacy of instructions to overcome prejudice than our decisional law supports. It also overlooks the misalignment of the instruction with the specific risk created by the denial of the motion to sever. 27. It is true that we generally presume that jurors follow the trial court's instructions. State versus Mason, 2003. Nevertheless, we have recognized that there are circumstances with which presumption is outweighed by the likelihood of prejudice, and that the jury could have found the defendant guilty of one charge based on, at least in part, upon the evidence regarding the other charge. Here, as the case was presented at trial, the jury was asked to determine which of the two adults who were with the victim on December 6th and 7th, 2019, the defendant or Kayla, killed her. While the jury heard no evidence that Kayla had ever physically assaulted the victim, it heard evidence from multiple witnesses that the defendant physically assaulted the victim in July of 2019. Thus, there was significant risk that the jury would draw the impermissible inference that because the defendant assaulted the victim before striking her in the head, he must be the one who fatally assaulted her in December by again striking her in the head. See Bean versus Cauldron, and that is 1998. Concluding the joinder of charges arising from separate incidents, allowing the jury to draw an impermissible inference of criminal propensity, which in turn allowed the jury to rely upon evidence in the stronger case to strengthen the otherwise weak case on other offenses. We conclude that under these circumstances, trying the second-degree assault and second-degree murder charges in a single trial jeopardize the defendant's right to a fair trial. 28. We do not agree with the state's contention that the trial court's instruction was sufficient to counteract the risk of prejudice to the defendant arising from trying the two charges jointly. The instruction said only that the jury must consider each indictment separately and that its verdict on one indictment could not influence its verdict on another. Nothing in the instruction, however, told the jurors that they were prohibited from considering the evidence admitted on one charge when reaching their verdict on another. The instruction then left the jury free to consider evidence of the defendant's assault on the victim in July when deliberating the second-degree murder charge. 29. The state asks that we attribute significance to the defendant's initial motion for joinder. The state asserts that the argument that the defendant advances now were available to him when he made that motion, and argues that the defendant does not explain on appeal how any of the items in the state's Wicker letter altered the analysis of that issue. The state contends that if the defendant's trial counsel could reasonably conclude that joinder under circumstances was proper and in his client's strategic interest, it is difficult to It is difficult to see how a trial court's ruling one way or another later in time could be clearly untenable or unreasonable to the prejudice of the defendant's case, and therefore an unsustainable exercise of discretion. Whatever the persuasive force of these arguments in the abstract, the state contended before the trial court that even if this Wicker letter provided no new information, the defendant had the right to withdraw his assent to joinder prior to trial and was entitled to a fresh consideration of whether joinder was in the best interest of justice. Accordingly, the state disclaimed in the trial court that the very argument makes it on appeal. We will not consider an appeal on an argument waived in the trial court. They're referencing C. Milliken versus Dartmouth Hitchcock Clinic from 2006. Having determined that joinder of the charges jeopardized defendant's right to a fair trial, we conclude that the trial court unsustainably exercised its discretion in failing to sever them. 30. The state nevertheless argues that even if the trial court erred by failing to sever the charges, the error was harmless. To establish harmless error, the state must prove beyond a reasonable doubt that the error did not affect the verdict. State versus Ralou from 2024, and they also reference Mason, applying harmless error standard to erroneous joinder of offenses. To determine whether the state has proven beyond a reasonable doubt that an error did not affect the verdict, we must evaluate the totality of the circumstances at trial. The factors that we consider in asserting whether an error did not affect the verdict include, but are not limited to: 1. The strength of the state's case. 2. Whether the admitted or excluded evidence is cumulative or inconsequential in relation to the strength of the state's case. 3. The frequency of the error. 4. The presence or absence of evidence corroborating or contradicting the erroneously admitted or excluded evidence. 5. The nature of the defense. 6. The circumstances in which the evidence was introduced at trial. 7. Whether the court took any curative steps. 8. Whether the evidence is of inflammatory nature. And 9. Whether the other evidence of the defendant's guilt is of an overwhelming nature. No one factor is dispositive. We may consider factors not listed above, and not all factors may be implicated in a given case. 31. The parties agree that the state's case on the July 2019 assault charge was strong and rested on testimony from several witnesses without the credibility defects that Kayla had. We conclude that the failure to sever the second-degree murder charge from the second-degree assault charge did not affect the verdict on the latter charge. That's referencing Tabish versus State from 2003, concluding the joinder of charges was improper where the state's weaker case on some charges was bolstered by combining it with the stronger case on another, so-called Casey counts, but concluding that given the strong and more than substantial evidence presented on the Casey counts, improper joinder was harmless beyond a reasonable doubt as it relates to the defendant's conviction on those counts. Because we conclude that any error with respect to the second-degree assault charge was harmless beyond a reasonable doubt, we affirm the defendant's conviction on that charge. So that's why they're not charging the assault again. The assault had nothing to do. They just said the murder charge with the assault is the problem. That the case on the assault was strong. Basically. 32. The state argues that any error with respect to joinder was also harmless as to the second-degree murder charge because the state's case and the evidence of the defendant's guilt were overwhelming. For the reasons discussed above, we disagree. The overwhelming evidence cited by the state, eyewitness testimony, testimony corroborative of the eyewitness DNA, fingerprints, receipts, and the list goes on, related to the uncontested charges of falsifying physical evidence and abuse of a corpse. By contrast, only Kayla's testimony directly implicated the defendant in the victim's death, and evidence that the defendant stated that he hated the victim right to his core, and that he effed up, are far from overwhelming evidence that he killed the victim. And that's referencing Mason again, concluding misjoinder was not harmless where the evidence was not overwhelming to any particular offense, and the case was dependent upon witness credibility. This is not a case, moreover, in which the jury found the defendant guilty on some counts and not guilty on others, which could have constituted compelling evidence that the jury considered the charges separately and was not influenced by the evidence of the other alleged offenses. State versus Cosette, 2004. We conclude that the misjoinder of offenses was not harmless as to the homicide charge. Additionally, we reverse the defendant's conviction of second-degree murder. Yeah. So I get what they're saying, and I think that reading this from the Supreme Court, it does make sense. It just sucks. I mean, let's just put it on the table. It just sucks. B. Other act evidence. 33. We address the defendant's remaining arguments because they are likely to arise again on remand. The defendant next argues that the trial court erred in admitting evidence of certain prior and subsequent bad acts as intricate to the charged offenses. Specifically, he challenges the admission of evidence that he punched the victim in the 2 weeks prior to December 7, 2019, and that he prevented the victim's mother from having contact with the victim throughout the 10 months preceding the victim's death. We review the trial court's ruling on the admissibility of evidence for an unsustainable exercise of discretion and will reverse only if it was clearly untenable or unreasonable to the prejudice of the defendant's case. Referencing State versus Papillion, 2020. 34. New Hampshire Rule of Evidence 404B prohibits the admission of evidence of a person's other bad acts for the purpose of establishing the person's propensity to act in accordance with character traits inferred from the other acts. We have distinguished between eccentric evidence of other crimes, wrongs, or acts, which is governed by Rule 404B, and intricate evidence, which is not. State versus Thomas, 2016. Other act evidence is intricate and therefore not subject to Rule 404B when the evidence of the other act and the evidence of the crime charged are inextricably intertwined, or both acts are part of a single criminal episode, or other acts were necessary preliminaries to the crime charged. Intrinsic or extricably, and those two are getting me, guys, especially the first one. Intertwined evidence will have a causal, temporal, or spatial connection with the charged crime. That's referencing Rulo from 2024. Typically, such evidence is a prelude to the charged offense, is directly prohibitive of the charged offense, arises from the same events as the charged offense, forms an integral part of a witness's testimony, or completes the story of the charged offense. 35. The defendant argues that the December 7, 2019 homicide did not depend in any way on the alleged abuse and neglect that previously occurred, or whether he blocked the victim's mother's contact with the victim beginning August 9, 2019. Testimony on those matters, the defendant argues, were not essential to providing an intelligent and coherent description of what occurred on December 7th. The state counters with respect to the prior abuse and neglect evidence that the trial court correctly ruled that this evidence was part and parcel of the crimes charged, understanding that events do not occur in a vacuum. It contends that the challenged evidence completed the story of the victim's murder, which cannot be fully understood solely by recounting the events of December 7th, 2019. In particular, the state argues that the evidence allowed the fact finder to see the full picture and understand that this case was not the story of a loving father who unimaginably snapped under formidable circumstances. 36. We conclude that the evidence of other assaults of the victim during the time the family was homeless was intrinsic to the second-degree murder charge, in part because the conduct was an essential part of the course of conduct leading to the charged offense. And yes, I cannot say that word. Sorry. I know the word, and it's just not coming out right, so my apologies. State versus Wells, 2014. The defendant concedes that this evidence bore an arguable temporal and spatial connection to the charged act, but argues that the requisite factual connection was lacking. And it's referencing rather Papillion, noting that while challenge statements by the defendants bore an arguable temporal connection to the charged offenses without a sufficient underlying factual nexus, these statements are merely coincidental to the charged offenses. We disagree. 37. In its objection to the defendant's motion to preclude this evidence, the state noted, a bit in the context of its Rule 404B analysis, that the prior conduct involved the same victim, an identical mechanism of assault, i.e., defendants punching and or striking the victim's face, and occurred under similar circumstances, i.e., in response to the victim's being incontinent in the defendant's vehicle. The challenged evidence described events that were a prelude to the charged offense and completed the story of the charged offense. This type of evidence is admissible under the rationale that events do not occur in a vacuum, and the jury has a right to hear what occurred immediately prior and subsequent to the commission of the charged act so that it may realistically evaluate the evidence. Evidence of the prior assaults gave the jury a more complete understanding of the alleged crime and better enabled the jurors to assess the likelihood that the charged crime occurred. That's referencing Wells again, discussing intrinsic evidence, prohibited value under a New Hampshire Rule of Evidence 403 analysis. Accordingly, the trial court did not unsustainably exercise its discretion in admitting this evidence as intrinsic to the second degree murder charge. That's going to be the word for the day, guys. I'm going to put that up. 38. With respect to evidence that the defendant prevented the victim's mother from having contact with the victim during the 10 months preceding the victim's death, the state argues that the trial court reasonably concluded that the evidence was intrinsic to the second degree murder charge because it formed an integral part of the victim's mother's testimony and completed the story of her contacting law enforcement, and because it directly undermines the defendant's assertion that he dropped the victim off with her mother in November 2019. 39. We disagree that the evidence was intrinsic under the rationale. The evidence lacks a causal, temporal, or spatial connection with the charged crime of second degree murder and is not intrinsically intertwined with that crime. While the evidence may have explained how the victim's mother came to contact law enforcement, it neither completes the story of the charged offense nor forms an integral part of a witness testimony about the charged offense. In addition, we have never held that evidence undermining a defendant's asserted version of events do not have a causal, temporal, or spatial connection with the charged crime is intrinsic to that offense. And it's got more references all here. Rather, we have considered the admissibility of such evidence under the rubric of Rule 404B, see State versus Duquette in 2000. Concluding that certain evidence was relevant for the non-propensity purpose of undermining the defendant's argument that she reasonably believed the alleged victim was about to use unlawful deadly force against her. We conclude that this evidence was not intrinsic to the charged offense, therefore the trial court unsustainably exercised its discretion in ruling to the contrary. This conclusion is limited to the determination that the challenged evidence is not intrinsic and does not preclude the state in a retrial from seeking to admit the evidence under 404B. And yes, I said the word correctly in this entire paragraph, and I don't know how I did that. So this is awful serious, but you gotta laugh when you can. C. Video of encounter with the police. 40. The defendant next contends the trial court unsustainably exercised its discretion in admitting a video of his encounter with the police on December 31st, 2021. Yeah, he did not like that at all. By motion, the defendant succeeded in having his statements during that encounter excluded because he had invoked his right to remain silent. See State versus Remick, 2003. Noting that under the Fifth Amendment, use of pre-arrest silence in the state's case in chief in which the defendant does not testify is unconstitutional. He then moved to exclude all evidence of the encounter pursuant to Part 1, Article 15 of the New Hampshire Constitution and the 5th and 14th Amendments of the United States Constitution, arguing that evidence that there was an encounter with the substance of the encounter is not admitted, merely raises questions and causes the jury to speculate and is therefore prejudicial. The trial court excluded only questions posed to the defendant, which resulted in his asserting his right to silence and any assessment of his demeanor based on his asserting his right to silence. At trial, a video of the encounter was played for the jury without audio. 41. On appeal, the defendant argues that the video was improper evidence of his pre-arrest silence. He asserts that in the video, the police officers appear to pepper him with questions that he seems to answer, but that without the audio, the jury could only speculate about what was said. He then asserts that the jury could have understood from other evidence in the case that the police had located him the day to question him about the victim. He argues that because there was no evidence that helped the police find the victim, the jury could only have understood that he did not cooperate, which constitutes the evidence of his pre-arrest silence. Well, he didn't cooperate. I mean, it's true, right? 42. Having reviewed the video, we cannot conclude it could lead the jury to speculate about the defendant's pre-arrest silence. The defendant acknowledges that, as depicted in the video, the defendant seems to answer the officer's questions, nor is there anything in the video suggesting that the officers were antagonistic toward the defendant or that he was fending off accusations. We are not persuaded that the video without audio constituted impermissible evidence of the defendant's pre-arrest Silence. 43. The defendant also argues that the video had no probative value on any issue of consequence. The state counters that the video was relevant and probative of the investigative steps taken by the police and was prohibitive of the defendant's whereabouts, with who he was with, and his living situation when the police began looking for the victim who was supposed to be with him. Based upon our review of the video, we conclude that while its probative value was slight, it presented virtually no danger of unfair prejudice. Accordingly, we reject the defendant's arguments that the video was unadmissible under New Hampshire Rules of Evidence 402 and 403. And it references, looks like New Hampshire Evidence 402 and then 403 mentions it there. Providing relevant evidence is excludable if its prohibitive value is substantially outweighed by a danger of unfair prejudice. We conclude that the trial court did not unsustainably exercise its discretion in admitting the video. You know, I really hope they can put the video back in with the audio for his next trial. I do. Conclusion. 44. Although the defendant requests that we reverse all of his convictions, well, of course he does, his brief does not specifically address his convictions of falsifying physical evidence, witness tampering, and abuse of a corpse. To the extent the defendant does challenge those convictions on appeal, he has failed to demonstrate reversible error. See State v. Letarte, 2016. Any issues the defendant raised in his notice of appeal but did not brief are deemed waived. See State v. Blackmere, 2003. 45. For the foregoing reasons, we reverse the defendant's conviction of second-degree murder, affirm his convictions of second-degree assault, falsifying physical evidence, witness tampering, and abuse of a corpse, and remand. And affirmed in part, it says reversed in part and remanded, and it's signed by the justices from the Supreme Court. That's the word of the day. Intrinsic. See, now I can say it. It's like when you're reading these motions and these court documents, there's always a word or two that they get me every time. They really do. But yeah, I mean, reading the Supreme Court's finding, it does explain it more than obviously that we got in a nutshell from, from the media. They already read it and then they told us, hey, they threw it out because unfair prejudice, because of the assault going onto this murder charge, that's what it is in a nutshell, basically. But yeah, at the same time, they did address some other things which were very important, like the body cam video. But yeah. So I don't know when Teardrop is going to get this other trial because from what I understand, New Hampshire is not in a rush to do much. But, he's not going anywhere. He's got 43, 44 years. I mean, he can stay comfy in his little cold cell, his little hole in the wall there. But he will eventually go back to trial for Harmony's murder. And I do hope that there is further evidence because by the time they take it to trial, there could be more. And yes, Kayla's going to have to testify again. So I know there's folks that are asking out there, well, is everyone going to have to retestify? Yep. Everything has to happen again. I mean, I'm starting to feel like this is a pattern. I mean, we had, Alex Murdaugh, and now we got, Adam Montgomery. I mean, what's next? I mean, it's just really, it's really sad for the victims in this, when when things get reversed. But at the same time, our justice system has a certain way it's supposed to work. And the Supreme Court, well, the state Supreme Courts are supposed to be the ones that make sure that the courts, district courts and such they're doing their job and things are, is being done correctly. And as much as we all hate, and yes, hate's a big word, even though it's a little word, but means a lot, that we hate Teardrop, Adam Montgomery, he does deserve a fair trial. And that hurts to say out loud. It really does. Because this little girl on the screen, she deserved so much more, and she never got it. She had a awful, awful life as soon as Adam and Kayla got custody of her. I cannot imagine the fear and everything that she went through in her final days with him. It's awful. But The good thing is she's been up in heaven, and she's been in a beautiful place, ever since December 2019, and she's been looking down, and she knows that there are many of us that never knew her, that we've grown to love her, and we support her, and we want this justice now that it does have to start over for her murder, that we want it to happen again. We want continued justice for little Harmony. But let me know you guys' thoughts in the comments. Um, I probably will go back through some of the case stuff in the coming months. Let me know if there's something specific you would like me to go through. Again, I have a playlist, so please do check that out if you haven't already. But with that said, I hope you have a great rest of the day, and most of all, stay safe.